We've got a whole hour planned for you. It's all Karen Reed.
It is, and this high-profile case for Karen Reed really has divided audiences into those that firmly believe Reed was set up by an elaborate police cover-up and those that are convinced Reed fatally hit her boyfriend, police officer John O'Keefe, with her car in a drunken rage.
But what does the evidence actually say? Let's start by taking a closer look at some of the Commonwealth's most compelling evidence against Karen Reed.
I found multiple pieces of red and clear taillight.
And where were they in relation to sort of the grid or the area that you had set up?
They were on the street in between the flagpole and the fire hydrant.
You know approximately how many pieces of that you were able to locate on that day?
I believe maybe 6 or 7 pieces.
And how big or how small or did they range in size as far as the pieces that you located?
There was 3 larger pieces, 2 red, 1 clear, and then a couple of smaller pieces.
And while a piece of blood was not found on Karen Reed's car, there was signs that the car had come in contact with John O'Keefe, including pieces of the broken glass the prosecutors were talking about there, and that glass that he was holding, as well as a single strand of his hair.
I was informed that this vehicle may have been involved in a hit and run, so I was requested to examine it for biological material.
And what, if any, information were you given upon arrival to the Canton Police Department in regard to that vehicle?
I was informed that the victim had scratches on his arm, as well as the fact that the car had been towed through a blizzard.
And did you perform any testing with relation to the vehicle?
Yes, I did.
And what was that testing that you performed?
I performed blood screening on the lower lying areas of the undercarriage, on each side of the tire flap, as well as the edge of the bumper and the exhaust pipe.
And what were the results of that testing that you performed there in the garage?
Those were negative.
And what, if any, evidence did you collect while you were either from the vehicle or from any other source while you were at the Canton Police Station that day?
I collected the apparent glass from the rear bumper. I collected a paint standard from the area of damage on the rear door. I also collected a paint standard from the area of damage on the rear bumper, as well as the apparent hair from the rear quarter panel, and I collected the taillight housing from the vehicle.
And Ms. Hartman, direct your attention up on the screen what's been now been marked as Exhibit 150. Do you recognize this?
Yes, I do.
And what, if anything, of significance in relation to items collected or items that you observed, do you observe in this particular photo?
I observed the apparent glass on the rear bumper.
And Ms. Gilman, if I could have photograph 2515. And again, up on the screen, what's now been marked as Exhibit 153. Do you recognize this?
Yes, I do.
Now, as far as that area that you were talking about where you recovered, which you termed initially in the garage as an apparent human hair, do you see the location of that within this photograph?
Is it possible to zoom in a little bit on the area right next to the rear chair light?
Come in if you could.
To the best of my recollection, it was in this area.
You recognize that?
Yes, I do.
And what do you recognize that to be?
That's the rear passenger area of the black Lexus.
Now, as far as the damage that you observed from the broken taillight, if you could, using the laser pointer before you, direct the jury's attention to that, or what's visible of that in this photograph.
This area here is the broken taillight.
And Ms. Gilman, if I could have the next photograph, 2540. This is now Exhibit 161. Again, Ms. Hartnett, if you could, using that laser pointer, direct the jury's attention to where you observe, if anywhere in this photograph, damage to the right rear passenger taillight.
There's damage in this area here to the rear tail light.
From the damage that you observed, it essentially wraps around from both the back and from the passenger side of the vehicle. Is that correct?
Yes, that's correct.
And it's hard to you recognize what's up on the screen as photograph 255400165.
Yes, I do.
And you were talking before, earlier in your testimony, about some stickers or some sort of evidentiary marker that you would put on an item that you're examining, correct?
Correct.
And do you see any of that in this photograph here?
Yes, I do.
And could you direct the jury's attention using laser pointer to where you observed that and what, if any area of damage or what that's to note?
There's a sticker here, and I know you can't see it. I don't know if you can zoom in.
You good, Mr.?
There's a letter on the sticker, I believe it's A, that denotes that there's something there that I was going to collect. And right next to that sticker here is the apparent hair that I noticed.
And similarly, it's hard to recognize anything in this photograph in regard to something that you had marked.
Yes, that's the rear bumper of the SUV.
And Ms. Gilman, if you could zoom in a little on that platform. And it's hard in this photograph, what, if anything, is depicted that you denoted something to sort of reflect or further examine that later?
There's pieces of apparent glass here on the bumper.
Now, earlier this week, a Massachusetts state trooper who specializes in accident reconstruction took the stand to tell the jury exactly how he believed O'Keefe was killed.
So the vehicle was traveling in reverse.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
What, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
All right, that was Trooper Paul, part of his testimony this week, talking about what he believed happened there, the Commonwealth's reconstructionist. But yesterday, we got a glimpse of what the defense wants to do with their own reconstructionists. Not actually their own. These were professionals that were hired by the federal government as part of that other probe.
Yeah, they made that clear, not hired by the prosecution or defense.
Yeah. And those guys, boy, they have some credentials. Let's bring in, live from Dedham, Massachusetts, Court TV crime and justice correspondent Matt Johnson. He has been all over this case from the very beginning. Also with us, criminal defense attorney and former prosecutor Franz Borchardt. Matt, let's talk about dark today. Map it out for us. What do we think is the from here on out in terms of scheduling? How much more does the state have, and what are we expecting from the defense? And I understand, we don't know for sure. These things change, but what are you forecasting, if you will, in terms of a schedule as we move forward?
Right. Ted, Kelly, good morning to you both. That's right. We're approaching the end of the Commonwealth's case in chief. They could rest as early as tomorrow, but we still have a lot of evidence that could go before this jury. The 15 that are in the box still hearing the case, that includes the medical examiner, that report. We haven't really seen much of that just yet. We could also hear some of the interviews that Karen Reed did outside of custody and, after she was arrested, that she gave to ABC News and other outlets, including Boston Magazine. So her own words might come back, which could force her in terms of, wanting to take the stand. Ultimately, it's up to her. But next week, we're expecting the defense case to be in full-blown action with a lot of their expert witnesses. And then the jury could have the case probably Thursday or Friday for deliberations.
Well, it's moving along.
Yeah, it definitely is.
And Franz, talking about the potential witnesses that defense counsel is going to call, obviously tomorrow we're going to hear from the judge who she's going to allow in. When we take a look at the state's theory, no canine DNA was present, and then you have defense counsel wanting to have this expert talk about that John O'Keefe's injuries look consistent possibly with a dog bite, a dog attack. How would that sit with the jury? You're saying no canine evidence present, but then you're going to have possibly, defense is going to have this expert that's going to say something different.
By saying in their opening statement, the defense promised us that they were going to show essentially that she's framed, right? That Karen Reed was framed. The dog piece is somewhat confusing. There are a lot of issues surrounding whether or not it was a dog bite, whether it is a dog bite, the absence of certain physical evidence if in fact it was a dog bite. I think her testimony is going to be very limited, if allowed at all. I think the defense's other two witnesses are coming in. Those are great experts. They sounded great yesterday. The bigger issue for the defense is the proclaimed, and I'm saying proclaimed, guys, because the judge has declared a discovery violation. Does she keep out anything based on the discovery violation? Does she look at the dog expert and say, you know, you're a little sketchy. You solicited to be a part of this case. They didn't seek you out. Does she limit her testimony? Does she disallow that testimony? I don't know yet. But I do think that the other two witnesses are definitely coming in, and I think they are going to really significantly help the defense.
Yeah, they just their credentials that we were listening to yesterday are very impressive, and you think that they're going to take what Trooper Paul testified to and bring a much different and maybe a deeper explanation for this jury. So we'll see. Let's get a break. When we come back, we're going to take a closer look at people that Karen Reed is accusing of being part of this conspiracy, what they had to say about the night in question. There's a lot of them coming up next.
Today,
the ultimate betrayals.
back-to-back episodes of Accomplice to Murder.
Spell was broken when the handcuffs went click. Friends and family turning on each other.
What he was willing to do for $1 million.
But just who is the puppet?
She was a master manipulator.
And who's pulling the strings?
An Accomplice to Murder marathon. Starting today, noon 11 Central.
Only on Court TV.
Sunlight is the best disinfectant, and it's vindicating.
I found multiple pieces of red and clear taillight.
There's pieces of apparent glass here on the bumper.
Did anybody see anything? What happened? And there was one individual that replied several times, I hit him.
Earlier, it was could I, did I? When she spoke to the paramedic, it was crystal clear. I hit him.
Are we going to get to see you testify? Tell your story?
If I have to, I will.
Wouldn't that be something if she took the stand?
Yeah, that should be risky.
Yeah, definitely. We are highlighting key evidence in the Commonwealth's case against Karen Reed this hour.
And aside from the physical evidence, some of the most compelling evidence comes from the testimony of the fellow party goers who were all at the Albert home on the night of January 28th, 2022.
And here's what they said happened that night and the morning after.
Brian Albert, Sr., just made a general, hey, I'm going to go home, have a drink with Brian if anyone would like to come.
After that was sort of put out to the table, what, if any, discussion did you have in regard to that with either Mr. O'Keefe, Ms. Reed, or both?
Both of them. I said, oh, you guys should come. Do you want to come?
And did they indicate that that was something that they wanted to do, or did they indicate that they were coming?
They both wanted to come, and they said they were coming, yes.
When she went outside, or when she was opening the door, her or somebody referenced that there was another vehicle out front.
And so, upon hearing that, where did you go?
Upon hearing that, we just assumed that was obviously John and Karen. So I don't recall if I looked out the window first or looked out the door first, but I looked out to see the other vehicle out in front of the house. I looked out again because it'd been a few minutes. Again, 2, 3, 4 minutes, I'm not sure how long, but it'd been a few minutes, and we thought it was weird they hadn't come into the house. Looked out and saw the SUV again.
And when you looked out for the second time, where was the SUV in relation to where it was the first time?
The SUV had moved up the road from the front of the house. It went from spot A to spot B. Now is further up, more in sync of where the again the flagpole, the utility box, the fire, more in sync with that. It had moved up the road. Thought it was weird that they hadn't come in.
So when you went over to the storm door and looked out, what, if anything, did you see?
I saw a vehicle.
And can you describe the vehicle that you saw?
I saw a dark SUV.
Now, as far as Miss Reed was concerned, were you familiar with what kind of vehicle she had at that time?
Yes.
And what kind of vehicle were you generally aware of her driving?
She had a Lexus.
And was that a sedan or an SUV, or what kind of vehicle?
I think it was like a small SUV.
Now, the vehicle that you saw outside of the residence of Fairview when you looked out the storm door, was that consistent with what you knew Miss Reed to be driving at that time?
Yes.
Yeah, so the first time I looked, I would say it was closer towards the mailbox, maybe a little bit in front of the mailbox. And then the second time, the last time I looked out the window, it had moved further down, closer to, I'll say, the flagpole. So closer that way, it went down that way, towards the flagpole.
And Ms. Nagel, with regard to the third point, or the third different location that you observed that black SUV on that morning, is that visible in this photograph?
Yes.
And again, using the laser pointer, if you could direct the jury's attention to where you observed it at the third point that you observed the black SUV. Thank you.
I did notice something out of the ordinary, like a black blob in the ground by the flagpole.
Can you describe how big an object it was that you saw?
I'd probably say like 5 or 6 feet, like long.
Karen brings us to the back of the car and she says, look, see, I have a cracked taillight.
And where on the vehicle was she directing yourself and Miss Roberts' attentions?
The back right.
So the passenger side, rear part of the vehicle?
Yes.
And when you looked at that area of the vehicle, what could you see at that?
I saw that there were missing pieces, but there was also snow covering it.
So as you came down the hill on Fairview, what, if anything, what happened then?
Jen said, my sister's house is right up here. And all of a sudden, Karen said, there he is, there he is. Let me the F out of this car. And she started kicking the door. She ran over to the mound.
And at that point in time, even when she runs over, could you see what she was running over to?
At some point, I realized it was the shape of a body.
All right, the Commonwealth also presented evidence of a failing relationship, painting Karen Reed as the crazy girlfriend, who O'Keefe was growing tired of.
What, if any, conversations would you have with Mr. O'Keefe in regard to any sort of relationships or dating or anything like that?
Well, he dated a lot of people.
After Mr. O'Keefe said, calm down, that's Laura's little sister, I said, hi, nice to meet you. That's when Miss Reed's head snapped up, and she very loudly told me to go myself across the lobby. My sister pulled me aside from everybody and asked if the night that I got into the altercation with Miss Reed in the lobby, if I was making out with Mr. O'Keefe.
How did you respond?
That I absolutely was not.
As we got by different landmarks, she then started, screaming, asking if John could be at certain people's houses.
And so Miss Reed is saying that in the car that morning as you're driving over to Fairview?
Yes, she asked, could he have been with Ashley? And I looked at her and said no, because to me that was a crazy idea. And then Carrie had mentioned, oh, do you think he could have called somebody else that lived on a street over? And she started screaming, who's that, who's she?
And you recall who Carrie referred to?
Yes. A woman that John had previously dated. She said something like, John really loved Amy, and in my eyes, Karen was just a babysitter with benefits.
At 2:25, John responds back, nope, things haven't been great between us for a while. Ever consider that? That was at 2:26. At 2:29, he writes, kids are here, not in the mood to talk. Can you please admit your head is out of the game with us?
If you could, sir, please continue on to the top of page 10.
Okay. At 2:32 p.m., sick of always arguing, fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently.
But the deciding factor for the jury could come down to Karen Reed's own words on the morning John O'Keefe was found dead in the snow.
Miss Reed was visibly upset. She kept saying, this is all my fault. This is my fault. I did this. And she was very hysterical. And she kept asking, he's dead. Is he dead? Is he dead?
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him, I hit him.
She just repeated the phrase over and over again, I hit him, I hit him.
Do you recall specifically what, if anything, that person said?
All I recall her saying was, is he alive?
When I asked her if there had been any significant trauma that happened before this.
What, if anything, did she say?
So she said, I hit him. She repeated it. There was a woman standing across from her who I believe at that point said, you're hysterical. You need to calm down. You're hysterical. She repeated, I hit him.
You indicated that the defendant said, I hit him, is that correct?
Yes.
That's something that she said once or more than once?
3 times. I hit him, I hit him, I hit him. Earlier, it was could I, did I. When she spoke to the paramedic, it was crystal clear. I hit him.
Why don't we bring in Court TV crime and justice correspondent Matt Johnston and criminal defense attorney and former prosecutor Franz Borgard. Thank you, gentlemen, for sticking around with us this hour. Matt, I do want to start with you and talk with you just about sometimes when you've been able to get some feedback from Karen Reed when you've talked with her, and then also just people out there in the community. When you're out there on the ground, living it every day, you've been out in Massachusetts for around 3 months, because I know you were out there in Daybell with me for a while, then you were sent right here to Karen Reed. Kind of just talk with me about your feeling and the sense, and especially when you're getting information from Karen Reed that we've been able to broadcast here on Court TV. I mean, really, it's really great to get that kind of, those kind of responses that you've been getting.
Right, and as you know, Kelly, a lot of times we don't have the defendant out of custody that is able to talk or willing to talk on camera. The O'Keefe family, they're asking for privacy. We ask them each and every day if they have any statement. They do not at this point in time. We respect that. But as for Karen Reed, this defendant, yeah, she says that there is plenty of reasonable doubt in this case, and she says that she's going to be vindicated. She talks to our cameras on the consistent basis almost every day outside the courthouse, and she says that, they haven't really proven anything, and she says that those text messages, along with all of the phone calls and possibly some of the voicemails that we're going to hear, is all part of a normal relationship, according to her eyes and her defense attorney's eyes.
Franz, to that point, the idea that the Commonwealth is saying, oh, she was so mad because they were possibly going to be breaking up or they were having some trouble with their relationship, she just ran him over in a drunken rage. I don't know. That's a tough one to take and buy.
That is very thin, especially if you read it in conjunction with the fact that she has a little side action going on, right? I think the better argument for malice, which is the standard in Massachusetts, the better argument is she knew she hit him and she left. And how do you prove that she knew that she hit him? I hit him, I hit him, I hit him. Not from one witness, not from 2 witnesses. How many witnesses did we see with that admission? Now, the counter argument is, 1, we know that she had at least 5 to 9 drinks. That's a fact in dispute, but between 5 and 9 drinks. Was she impaired such that she would have admitted to anything, right? Was she in shock and such that she said statements that are patently false? It's hard to discern it, but man, oh man, is that powerful testimony, powerful witnesses, unless, of course, guys, it's all a conspiracy and they're all lying to frame her.
Right. So did she have to take the stand to clarify that and say, I hit him was a question and my mind was jumbled?
I think what is interesting is she has framed her testimony with, I want to testify, but it's up to my attorneys, which is kind of true, kind of not true. So it's kind of true in the sense that she's going to listen to her attorneys. But guys, the only person that decides whether or not Karen Read testifies or not is Karen Read. It is sacrosanct. She is the one who makes that decision, not her defense team. Now, to be sure, she should listen to her defense team. I think she has to take the stand to clarify what she said. There's no other way of clarifying it. There's no other way of anybody else saying she was in shock. She was mistaken. She was impaired such that she would have said where Hoffa's body it was. Only she can clarify that. But I think she would make a terrible witness, and I don't think she will testify.
Yeah, I wonder just how she would do with the state, the Commonwealth questioning her. I don't know if it would go too well. Franz, thank you. We're going to get in a quick break.
I got faith in her.
You have faith in her? Well, I mean, of course we would love to hear from her.
Yeah, I want to hear her story. And, you know, she's a very intelligent woman. You could tell that when she's talking to Matt.
Yes.
She's very, she's very intelligent, and that sometimes she's very confident. Sometimes that backfires when you try to outsmart the prosecutor.
All right, we're going to get in a break, though, but coming up, the defense's case and what evidence could help their client, Karen Read, in the killer or cover-up murder trial. So stay tuned. You are watching Court TV, your front row seat to justice.
Today, the ultimate betrayals. Back-to-back episodes of Accomplice to Murder.
Spell was broken when the handcuffs went click.
Friends and family turning on each other.
What he was willing to do for $1 million.
But just who is the puppet? She was a master manipulator. And who's pulling the strings? An Accomplice to Murder marathon. Starting today, noon 11 Central. Only on Court TV.
Welcome back to Court TV Live. Along with Kelly Graff, I'm Ted Rollins. Glad to have you along with us. Courtrooms are dark across the country today, so we're kind of looking back at where we are in the Karen Read case. And now we're getting into some key evidence highlighted by the defense for defendant Karen Read.
While the Commonwealth says that Read killed Officer John O'Keefe, the defense believes that he was actually assaulted inside the home of the Alberts and that some of his injuries were inflicted by the family dog.
On cross-examination, Nicole Albert was questioned by Read's defense attorneys about why they ended up rehoming Chloe the dog to another state just months after John O'Keefe was found dead in their front lawn.
You testified that your German Shepherd, Chloe, was also at the house when you arrived home on January 29th, correct?
Yes.
She's a large German Shepherd.
Yep, about 70 pounds.
She's not great with strangers.
I wouldn't say that.
You wouldn't say that it's kind of a poorly worded question. Would you say that she's good with strangers?
I'd say she's fine with strangers.
Fine with strangers. Ms. Albert, Chloe has injured other humans, hasn't she?
Objection.
I'm going to allow that. In one incident in May of 22, when she got out and was fighting with another dog, the woman whose dog it was tried to break up the two dogs, and while she was trying to break up the two dogs, she got injured.
Ms. Albert, you don't have Chloe anymore, do you?
Nope.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
Oh, is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Your dog is no longer in the Canton area, correct?
No, but I know where she is. She's in Vermont.
All right, Chloe's rehomed in Vermont because of the dog biting incident. Matt Johnson's still with us for the hour, and Franz Borchardt. So, Matt, this Marie Russell, this is the expert that the defense sort of fell into, a woman that was made aware of the trial. She's retired. She came in to be voir dired yesterday. She's all in on this dog bite theory, but we don't know, do we, if she's going to be able to take the stand.
Correct, because she's the wild card. She is the Rule 14 violation for the Commonwealth, so they're asking for her testimony to be stricken, that the jury cannot hear her testimony. But the judge did say, Judge Cannoni, she said, Commonwealth, you have a week to find a rebuttal witness. So it sounds like she's going to be allowed in to testify. And she comes with a lot of knowledge of dog bites. She's a former ER doctor. She's a former police officer herself. She's retired now. She has published articles about dog bites. She says it's consistent, the injuries on John O'Keefe's arm to a dog bite. And you know what? That's the million-dollar question. Why did the Alberts get rid of this dog that they had for 8 years that had a history of biting people in the past? And why did the investigators on this case not swab his arm for dog DNA? They swabbed the middle of his shirt. That's what was tested.
Yeah, and Matt,
point.
we'll bring in Franz on that. It is suspect that the dog, and we heard the witness on the stand say, well, I didn't get rid of him. I rehomed the dog. I mean, the timing, it's quite a coincidence.
All of this is suspect, right? This is the craziest stuff I've ever seen, right? The fact that they would relocate the dog makes no sense, right? You know, the fact that there's an absence of DNA evidence from canine, there's an absence of fur, there's an absence of all sorts of things. There's speculation as to whether or not Chloe had bottom teeth or not. The whole thing's crazy. And additionally, you know, Ted framed it as the defense fell into this expert. Let's not mince words. She solicited to be a part of the case, right? It's a high-profile case. She solicited to be a part of it. She made a conclusion without looking at all the evidence. She waffled a little bit on the stand with regard to, is it an animal bite or is it a dog bite? She was also opining about stuff that was kind of outside of her expertise. I just don't see her coming in as an expert, or if she does, it's going to be, you know, it may be a benefit to the Commonwealth. I don't know. But the fact that Chloe has been relocated, I need that explained to me. That doesn't make sense to me. Do you get rid of your dog? I love my dog. I'm not going to get rid of my dog. I'm not going to relocate my dog.
Yeah, and get rid of your phones, too. I'm not getting rid of my phone or relocate. Go ahead, Matt.
I was going to say that, Ted. You know, we have 2 police officers, law enforcement background, that are witnesses in this case, key witnesses, including the homeowner. They get rid of their phones the day before they were going to be asked to preserve it by court order. You also have the selling of the home, the remodel of the basement. You have the rehoming, or getting rid of, the dog after 8 years of that being a family member in your home. So you have all of these things that are going to be in the minds of the jury and that are going to be brought up by this defense team in closing arguments.
Absolutely. Yeah. Defense has so much to work with.
It's called reasonable doubt
in this case. All right. Break time.
Yeah, let's get a quick break. Then we're going to talk more Karen Reed right after the break. We're going to talk about the defense and what are they going to do? I mean, people think they're winning right now. Do you just sit back? It doesn't seem like it. They have a defense all planned with some expert witnesses. We'll preview what we expect from the defense right after this.
This is an innocent woman. She didn't do it.
It's a controversial case that's divided a community.
Karen Reed is accused of murdering her police officer boyfriend.
Prosecutors say she ran him over on purpose and left him to die in the cold.
But Reed claims that she's being framed.
It smells suspicious.
After years of legal fireworks, will the truth finally be revealed?
The end game is to figure out who killed John O'Keefe and hold these people responsible.
The killer or cover-up murder trial. Live coverage today, only on Court TV.
Welcome back to Court TV Live. If you're wondering, hey, where's the live testimony in Karen Reed today? Well, courthouses across this country are dark today in observance of the Juneteenth holiday, giving us a chance to highlight some of the key evidence in the defense case and the state's case in the Karen Reed trial. Big part of the defense case is this, quote, shoddy and biased investigation by the lead investigator, Massachusetts State Trooper Michael Proctor.
And perhaps the most shocking part of Proctor's testimony, those unprofessional and regrettable, he used those words, text messages that he sent to family and friends about the defendant during his investigation. Let's go ahead and listen to some of those.
So these came from a
From all accounts, he didn't do anything wrong. She's a whack job.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Yes, she's a babe. Weird Fall River accent, though. No ass.
And sir, what is it that you were referring to there, or why would you text that?
These were, from all accounts, he didn't do anything wrong. Is talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Miss Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
Still with us, Court TV crime and justice correspondent Matt Johnson and criminal defense attorney and former prosecutor Franz Borgart. All right, gentlemen, Matt, going to start with you. Listening to Proctor there, after he testified, I went and I was reading a lot of the papers, the newspapers from the New England area, and wow, just some of the things that were said and some of the op-eds that were written, some of the editorials that were written talking about if you are a man who thinks this way, apply to the Massachusetts State Police.
There's one right there Matt's got holding up there.
Oh, you have one? Oh, I see it now. Yeah, we want you. Matt, talk about that stuff, because, I mean, the hits the Massachusetts State Police Department has received over his testimony and what he was saying. I mean, it's not good.
Well, you know, there's a ripple effect in this community. For one, this community is completely divided on this particular case for a number of issues, but then you have the issue and the distrust now in state police. And I talked to a lot of state police officers, including some off camera that are here guarding the courthouse during these key witnesses when they enter and exit. And, you know, for the most part, law enforcement is ashamed of hearing that type of testimony, that type of language, that getting into this case whatsoever. When I was in court during Trooper Proctor's testimony, jurors were just sitting back, arms crossed. They were shaking their head, and especially not just the words that he was speaking of this defendant and his hate for the defendant, also saying that she hoped that she committed suicide, but the fact that he couldn't remember his relationship with the Alberts. It went from I don't know them to they're an acquaintance to I would have them babysit my baby. But it's something that you can't escape here. I brought these in to show you. This is after his testimony. This is what the headline was in the Herald. Right after, that's a change from the beginning of the trial in April when this was the headline about what she said and several witnesses. Again, here's another headline saying that, is he dead? And then you have it all over the Boston Globe. You can't escape the radio or television. Every time you turn on your television, it's continuing coverage. It's another update on the case. Everybody is paying attention to this case, and I mean everybody.
Yeah, and people that they have roots there. I've noticed, you know, friends of ours that are, you know, they know people there. They used to live in New England. Oh my gosh, they're glued to it. You know, you got your Carrie Tuttles, your Colleen O'Donnells. They're absorbing every bit of it, Franz. And the Trooper Proctor testimony. He's the lead investigator. I mean, this to me is it's game over-ish, or maybe not. Am I reading too much into it? But for a juror to say, yeah, I'm going to find her guilty because I believe in this investigation, when you have this guy leading it.
So I have predicted, Ted, guys, I think she's going to be acquitted. And in large part, I think she's going to be acquitted because of the text messages, which, if you think about it, horrible text messages, horrible optics, but does it really change the facts of the case one way or another? Not necessarily, but those bad optics have that, what Matt said, a ripple effect, right? So the ripple effect, all of a sudden, it's like, can the jury hear past those text messages? And I don't know that they can. And in a case that's already a defense attorney's dream, there's possible reasonable doubt all over the place, guys. that is just the cherry on top. This trooper, to me, those text messages were in large part what torpedoed the Commonwealth's case.
Yeah, I mean, for certain. It's just, just to that point, I just have a hard time believing that, you know, a jury, when defense counsel is going to get up there in closing and talk about Proctor, I mean, you really just have to say, as a jury, in a way, this investigation was biased. How can you convict a woman when the investigation was botched like this? It's just a tough one. Matt, talk to us a little bit more about the sentiment out there in the, you know, amongst the community, their thoughts.
So when you go to get your hair cut or you go to the grocery store and you say you're visiting from out of town, they say, what are you here for? And then you mention, I'm a journalist and I'm here covering the big trial. They go, oh, I've been instructed not to talk about it. It's like talking about politics here. Of the supporters of Karen Read that are 200 feet away from the courthouse entrance that wear the pink shirts, the Free Karen Read signs, they hold the picket signs, they all say that, you know, a couple of them tell me that it's divided their households, that they've lost contact with family members over this. It has really divided this community, and it's going to be interesting to see when the verdict comes down how that is going to be felt and what happens next.
Yeah, talking about a verdict that is going to be, you know, stop what you're doing.
Yeah.
The jury's back. It's going to be unbelievable. Yes, thanks, Matt Johnson, Franz, as well. We're going to get a break in here, but there's much more ahead.
Stay with us. We're coming right back.
So there's a cover-up, and if so, who's leading the cover-up?
Your guess is as good as mine. That's what we're trying to figure out. That's exactly what we're trying to figure out. The Massachusetts, well, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them.
So you have a Boston police officer who's found dead on the lawn of a Boston police officer's home. Why was there no search warrant done of that home? Why was there no search for forensic evidence that he entered that home? That would have been done if it were you or me who owned that home.
The dog has been gotten rid of. Got rid of the evidence in the basement. Got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose.
It makes no sense to me. I think it's going to make no sense to a jury.
And welcome back to Court TV Live. I'm Kelly Craft, along with Ted Rollins. This high-profile murder trial for Karen Read in Massachusetts does get back underway tomorrow. So right now, we want to take a look back and a look ahead as well to what we're going to see from defense counsel.
Yeah, the prosecution accuses, of course, Karen Read of hitting her Boston police officer boyfriend John O'Keefe with her vehicle and then leaving him to die in the snow. The defense says that, well, there's several other scenarios that could be to blame here, including O'Keefe was killed during a fight inside the Alberts home and dragged outside, or that he died from a dog attack.
You'll remember back to opening statements in this trial, and the defense was not allowed to mention their third-party culprit defense. The judge is only allowing it to come in as evidence unfolds throughout the trial. One of the key pieces of evidence for the defense is Karen Read's own words during a police interview when she was taken into custody in June 9th of 2022. Let's take a look at some of what she said, the statements that she said, and statements she's made on the steps of the courthouse.
So, initially, your arrest was on probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death, okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay? So bail doesn't apply anymore? Typically, I'm not. So we don't set the bail. But typically, once murder comes into play, people are going to get bailed out. So So it's not manslaughter anymore, is that the difference? That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury. Okay, you're aware he was beaten up by Brian Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized. Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to your rights, okay? And I'm sure he's going to do it again. All right. If you want to talk to us, you want to give us a story, definitely. But we'll take it. No, I mean I know you already know the story, so I don't need to. Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. Yeah. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
I never get tired of watching that when Alan Jackson then steps up and says, no, she didn't do it. We do want to bring in our guest to discuss. Joining us now from New York, trial attorney Cannon Kearney. Cannon, thanks so much for being with us. You know, whatever side of the aisle you fall on in this case, I always want a defendant to have such great representation, a vigorous defense, and we are seeing it here. And I really do feel you read the comments on social media, again, whatever side you're on, and the fact is, anyone who would be in Karen Read's shoes would want defense counsel to be fighting for her like these guys are doing for her here.
That's correct. Good morning, Kelly and Ted. Great to be here. Happy Juneteenth. And in honor of Juneteenth, we have another cover-up story. We have individuals just like this who've gone through this type of scenario in the black community, whether that be Eric Garner or Breonna Taylor or Rodney King. And they needed representation just like Ms. Reed. So you are 100% correct. A defendant in these shoes would want somebody who sees their story, who understands what they're going through, and who can articulate that in a way to the jury that they can be found acquitted for the crimes that they've been seen. So in this scenario, it's clear Ms. Reed's defense is fighting for her, just as those individuals that I just discussed would have wanted their defense to fight for them as well.
Absolutely.
Yeah, what's interesting is she's also fighting. She is not holding back with her comments, and she talks to Matt Johnson very regularly outside of the courthouse after days. Let's listen to a little bit of the exchange between Matt and Karen, and then I want to get your take on whether or not she is the type of person that should or could take the stand and be successful. So first, let's listen to her talking to Matt.
There is no case against me.
After 8 weeks.
After 8 weeks, it's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
Have you thought about what it would be like to be on the witness stand yourself?
Yeah, I have. I'd like to fill in some holes and correct some lies, but it's up to the attorneys, and they'll make the call probably at the 11th hour, and I'm there or not there.
You're lobbying, though, for your chance to testify?
I'm an outspoken person, and I've never not been able to speak up for myself and my defense, except when it matters the most. I've got to rely on them and their expertise, and I'll defer to the attorneys.
Cannon, an articulate defendant, is this someone you want to put on the stand, or would it give you pause because she's also very combative? She is a fighter, and you don't necessarily want her going toe-to-toe with Prosecutor Lally on the stand in front of the jury. What's your take? Did you put her on?
Well, Ted, to be truthful, I usually inform my clients to say the least amount to the media or to say the least amount on social media. Why is that? Because everything that they say can now be used against them. In this scenario, we have a very attractive white woman who articulates herself well, and for the stand and for the jury, she may actually be able to persuade or have the jury to understand exactly her thoughts of why this is a cover-up, understand exactly her thoughts of why it is that she did not actually commit the murder that she's been accused of. So in this scenario, her attorney must be giving her information that says that they believe that her fighting in the media is the best route to move forward. That's not something that I normally do with my clients, but I can see why her attorney may be informing her to do that for this specific trial.
Yeah, Ken, and it is surprising to see because we usually don't see something like this.
But it's been successful in that, I mean, what other case do you have people showing up in huge numbers?
Yeah.
I mean, before the trial even started, they were showing up to pretrial motion hearings, which usually it's Deadsville. The courtroom is, you know, there's 2 or 3 people in it, you and maybe Matt.
Sure.
And but
Sure.
these were packed because of the amount of exposure that the public has received in this case. I think it'd be shocking if the jury didn't know that the world was watching. They have to know, especially when you have all these people standing outside the courthouse.
Yeah, Ken, have you been involved in a case that's gotten this much attention and support from the community?
Oh, I wish. Essentially, in my time, the cases that I've gone through have some community presence, but this is one where the world is watching. This is one where people actually have a stake in seeing whether or not this defendant is actually going to be able to stick it to the man or be able to overcome this police cover-up. So have I had a police cover-up case? No, but I am definitely grateful to be on Court TV explaining why it is that Ms. Reed looks like she's in a position to be acquitted for this police cover-up.
Yeah.
So, it is amazing the amount of people watching. How, Cannon, one of the questions that everyone has everyone has a different opinion, and that is, what happened? And how can you have a criminal case when that's going to stand up when no one knows what happened? I mean, there's so many different theories. Well, I think it was the dog. I think it was the snowplow. I think it was the tail light that somehow jumped out and grabbed his arm. There's so many different scenarios here. Do you think the defense is holding on too tight to the Chloe the dog in the house, he gets beat up, that whole scenario, and that they should maybe just open it up to, hey, we don't know what happened, and guess what? In this country, that means reasonable doubt.
Well, Ted, I think that's a very good point that you're bringing up. So the defense, their main theme should be that the police did not adequately or professionally conduct the investigation needed so we can actually have an answer to what actually happened. So as long as they continue to show that the head investigator was best friends with the individuals who own the home, or that the police didn't bring evidence until approximately 26 days to a month after the actual crime occurred, they can continue to now throw out all of these different ideas so that one of the jurors can say, you know what, that may actually be right. And in America, in the courtroom, when there's a may actually be right, what does that lead to? Reasonable doubt. So as long as they continue to throw these out, as long as they continue to prove that the investigation wasn't done the way that it should have been done up to compliance with the standards that the state has put forth for investigators, then I believe that they need to continue to throw things out for the jury to be confused.
Mm-hmm.